Good day everyone. We will discuss today compound crimes. This is the first kind of complex crime which we will discuss under Article 48 of the Revised Penal Code. But before proceeding with our discussion, please bear in mind that this audio lecture through PowerPoint presentation is merely a supplement to your study of criminal law. It does not seek to supplant your reading materials nor contradict what your professors have discussed to you about the subject matter. As you read the slides, it is best that you read the codal provisions first, so you will have a better grasp of the important points that I will be emphasizing throughout this presentation. The main sources of my discussion are from the notes and cases on the Revised Penal Code by Leonor D. Buado, and of course, from the Revised Penal Code by Luis B. Reyes. I have endeavored to harmonize the opinions of these two great authors, hopefully for your better understanding. Lastly, this is not an attempt to present myself as an expert in the field, but merely to share my knowledge of criminal law, grounded upon my experience as a prosecutor for the past 11 years. So let's start the ball rolling. What is the legal basis for the existence of complex crimes? The legal basis is found in Article 48 of the Revised Penal Code, which states, and I quote, "When a single act constitutes two or more grave or less grave felonies, or when an offense is a necessary means for committing the other, the penalty for the most serious crime shall be imposed, the same to be applied in its maximum period." Now, under Article 48, there are two kinds of complex crimes. The first is the compound crime, where a single act produces two or more grave or less grave felonies. And the second one is the so-called complex crime proper, where an offense is a necessary means to commit the other. Now, here, for both compound crime and complex crime proper, at least two crimes must be committed. And even if at least two crimes are committed, or two or more crimes, if that be the case, in the eyes of the law, it is treated, or they are treated only as one crime because it proceeds from a single criminal resolution or intent. Since they are treated as a single crime, then there is only one penalty to be imposed for their commission. And what is the penalty to be applied? The penalty for the most serious crime shall be imposed, the same to be applied in its maximum period. Now, when you say penalty for the most serious crime, what does that mean? It actually means the higher penalty imposable between the two crimes, or the highest penalty imposable among the crimes if there be more than two crimes committed. Now, the higher penalty or the highest penalty will be the one imposed, and the same is to be imposed in its maximum period. For example, in the complex crime of estafa through falsification of a public document, estafa is punishable by prison correctional maximum to prison mayor minimum. On the other hand, falsification of a public document is punishable by prison mayor as a whole. So between the two crimes, estafa and falsification, falsification is the most serious crime because it has the higher penalty. Now, in such a case, the penalty for falsification will be the one imposed, and the same will be imposed in its maximum period. So, since the penalty imposable is prison mayor as a whole, and you already know that prison mayor as a divisible penalty has a minimum, medium, and a maximum, then under Article 48, if the accused is convicted for such kind of complex crime, the penalty to be imposed upon him is the penalty of prison mayor maximum. Okay? This is, of course, without prejudice to the application of the indeterminate sentence law, which we have already discussed previously. Now, in what way does Article 48 benefit the offender? It benefits the offender because instead of having to serve 2 or more separate penalties, he only has to serve 1 penalty. What is a compound crime and what are its elements? Its elements are, number 1, that the offender commits a single act. And number 2, that single act produced 2 or more grave or less grave felonies. Now you might ask, what constitutes a single act? This question is better answered by providing you with some examples. First example, the single act of firing a single bullet, hitting and killing 2 or more victims. It could also be the single act of throwing a hand grenade, exploding and killing several people. It could also be the single act of the accused stabbing a judge while the judge was presiding the hearing of his case. And it could also be the single act of stabbing a pregnant woman, causing her death and that of the fetus in her womb. Now, in all of these 4 examples, you could readily observe that these single acts produced in them at least 2 crimes. In the first example, it produced 2 crimes because it resulted in the death of at least 2 people. The same goes for the second example. Now, in the third example, it produced 2 crimes because the act of attacking or stabbing a person in authority like a judge will not only produce the crime of attempted homicide or attempted murder or homicide or murder as the case may be, but it will also produce the crime of direct assault. Okay? Now, the act of stabbing a pregnant woman will not only produce the crime of homicide or murder for the death of the pregnant woman, but it will also produce the crime of abortion because it resulted in the death of the fetus. Okay? Again, let me emphasize that this single act must produce 2 or more grave or less grave felonies. For a better understanding of what grave or less grave felonies are, I will show to you their definitions pursuant to Articles 9 in relation to Article 25 of the Revised Penal Code. So here it is. Grave felonies. Grave felonies are those to which the law attaches the capital punishment or penalties which in any of their periods are afflictive. For example, reclusion perpetua, reclusion temporal, or prison mayor. Now, you will notice that if felony is considered as grave or less grave, depending on the penalty attached to it. Meaning to say, if the penalty attached to it is considered afflictive in Article 25 of the Revised Penal Code, then that felony should be considered as a grave felony. And you will also notice here that I put an asterisk before the word capital punishment or the term capital punishment. Why? Because we have no more capital punishment as of the present in view of the abolition of the death penalty by Republic Act 9346. Less grave felonies. Less grave felonies, on the other hand, are those which the law punishes with penalties which in their maximum period are correctional. For example, prison correctional and the penalties of arresto mayor or distierro. Light felonies are felonies or infractions of law for the commission of which a penalty of arresto menor or a fine not exceeding 40,000 pesos or both is provided. Again, you will observe that felonies are considered grave, less grave, or light depending on the penalty or particular penalty attached to it, pursuant to Article 25 of the Revised Penal Code. Now, also take note, and this is very important, that to constitute it as a compound crime, it must be a combination of, number one, either two grave felonies or two or more grave felonies. Number two, two or more less grave felonies, or it could also be a combination of one grave felony and one less grave felony, or one or more grave felonies and one or more less grave felonies. Examples of grave felonies are murder, homicide, rape. Examples of less grave felonies are less serious physical injuries or direct assault. Example of a light felony is slight physical injury. Now, these are not just the only grave, less grave, or light felony out there. No, there are lots and lots of grave felonies, less grave felonies, or light felonies. These are just, as I said, examples to give you an idea what these crimes are. Now, this is very important. Compound crimes refer only to felonies. Take note. You already know that when you talk about felonies, they are crimes that are punished under the Revised Penal Code. Never call a crime punished outside the Revised Penal Code as a felony, because the term felony, as I have previously emphasized, it is a term exclusive to crimes punished under the Revised Penal Code. Now, for compound crimes to exist, they must refer to felonies. And as such, they cannot be complex with offenses punished under special laws, even if both the felony and the offense resulted from a single act. Now, also take note, and this is also very important, if the other felony produced is only a light felony, then it shall be treated as a separate crime. So for example, in that single act of throwing a hand grenade, resulting in the death of two persons and causing only a slight physical injury, a hematoma on a third victim, how many crimes are committed? There are two crimes committed. The first crime committed is the compound crime of multiple murder or homicide because of the death of the two victims, and a separate crime only of slight physical injury, because slight physical injury, as I have already said, is only considered a light felony, and being a light felony, according to the law, it shall be regarded as a separate crime. Now, is there a single act that does not result to a compound crime? The answer is yes. The single act of pressing the trigger of an automatic submachine gun will not result to a compound crime. Allow me to explain this by giving you these examples. Example number 1. X, with the use of a submachine gun, fired the same at a crowd which killed 10 people. Here, there will be as many offenses as the number of victims killed. Reason? Although the burst of shots was caused by a single act of pressing the trigger, it will not be considered a compound crime because of the special mechanism of the said weapon, so much so that the person firing it only has to keep pressing the trigger to make it fire continuously. It is not therefore the act of pressing the trigger but the number of bullets that produce them that will be the basis of criminal liability. Example number 2. X, with the use of a revolver, fired at Y. The same bullet that hit Y also hit Z. Here, there is only one crime, that of a compound crime. Example number 3. X, using his pistol, fired at Y and thereafter at Z, killing them in succession. Here, there is no compound crime because they are considered distinct acts, meaning to say the act of X in firing at Y and the subsequent act of X in firing at Z will be considered distinct acts. And since they are considered distinct acts, then separate charges will be filed against X for the injuries or death caused to Y and Z. Example number 4. X, a political warlord, ordered his men to fire at a rival crowd. The firing did not stop until X ordered them to stop, killing 30 people. Here, if it cannot be ascertained how many were killed by each of the men who was ordered to fire by X, then X and his men will only be liable for a single offense of multiple murder. Because here, the acts will be considered as a result of a single criminal impulse. Now, let it be emphasized that this rule only applies when or if it cannot be ascertained how many are killed by each of those persons who were ordered to kill. Okay? Now, the rule on compound crimes is also applicable to crimes committed through negligence. Examples: X accidentally discharged his revolver, killing Y and Z. Okay? Again, if you notice, there is a single act of X accidentally discharging his firearm. And it produced at least 2 crimes, killing Y and Z. So, even if it is a crime committed through negligence, it can still be regarded as a compound crime. No? It will result in the crime of reckless imprudence resulting in multiple homicide. Another example, X, in a hurried attempt to overtake the vehicle in front of him, encroached on the opposite lane and collided with a motorcycle driving on the said lane, killing X's passenger and seriously injuring the driver of the motorcycle. Here, there will only be one crime committed. That is the crime of reckless imprudence resulting in homicide and serious physical injury. Because there is only one act and it resulted in at least two crimes. Okay? That of homicide, the death of X's passenger, and that of serious physical injury, the injury caused to the motorcycle driver.